Hello, everybody. Good weekend to you. It's Dave Neal, stand-up comic, host of the Rush Hour podcast, and we have Justin Baldoni's attorney, Brian Friedman, shredding the New York Times as he responds to their motion to dismiss. I'm going to share what he has to say. I've highlighted some of the juiciest parts. I'm also going to share what Lady C had to say on Twitter regarding this takedown. So why don't we do this? Let's read some of the aspects of the motion. I've got the full 36-page right here. We're going to start on page 11, but as you can see, it's Blake Lively plaintiff versus Wayfarer, then it's Wayfarer plaintiff versus Blake Lively. It's a dueling lawsuit, all consolidated into one, at least for pretrial purposes. Part of the argument by Justin Baldoni is going to try to get their case against the New York Times in California to get away from some of the generous laws that exist in New York State. And of course, that's where the New York Times is located. But they argue your defamatory statements affect my client specifically in California. And you know, this modern world we live in with the internet really makes it that you're damaged no matter where the defamation takes place. So let's skip on to page 11 and start with the preliminary summary. I'm going to share about 8 pages of this. A pietistic bastion of the media establishment. And by the way, pietistic means of or relating to religious devotion or devout persons. You know it's going to be a good one when you have to use the dictionary for the first word. A pietistic bastion of the media establishment, the New York Times has long presumed itself beyond accountability. Not here. The New York Times went past merely reporting on plaintiff Blake Lively's California Civil Rights Department complaint and actively vouched for the veracity of its false narrative. The fair report privilege the New York Times seeks to hide behind does not protect it from liability for maliciously colluding with Lively and her cohort to publish a false and defamatory hit piece about the Wayfarer parties, wrongly casting them as villains and making them scapegoats for Lively's well-publicized media missteps. On December 21st, winter solstice 2024, the New York Times published a story titled, "We Can Bury Anyone Inside a Hollywood Smear Machine." In a related video, they shared the video featuring New York Times journalist Megan Twohey, who co-wrote the article along with Mike McIntyre and Julie Tate, purporting to tell the world what really happened. Specifically, that the Wayfarer parties orchestrated a retaliatory campaign to tarnish Lively after she alleged that Baldoni and Heath engaged in misconduct while shooting the film. The article and video echoed and compounded the baseless accusations made by Lively and her co-defendants, the Lively parties, about the Wayfarer parties and falsely accused them of having waged a smear campaign. So we know all of this, all right. You know, this is just a summary to catch people up to the story. But that is not what the New York Times did. It admittedly based its article and video on its reporter's review of thousands of pages of documents and expressly credited Lively's claims, framing them as having been verified by the New York Times' own investigation. In doing so, the New York Times forfeited the fair report privilege. So, Baldoni's saying, hey, it just wasn't fair. And we're going to get into the part where Brian Friedman argues, you gave us a couple hours to respond. We scrambled, and you still published it before we could even get our response to you. We'll get to that. The New York Times prepared its salacious article well before Twohey contacted the Wayfarer parties the night before publication for quote-unquote fact-checking. After the New York Times' months of plotting with the Lively parties, the Wayfarer parties got hours to respond. The New York Times complains of group pleading, claiming it cannot tell the allegations against it from those against its co-conspirators. Of course, it is premature to require the Wayfarer parties to specify the acts taken by the New York Times in connection with its scheme with the Lively parties. A jury will determine the truth based on the evidence, but the Wayfarer parties' allegations are clear. The New York Times argues New York bars 2 California tort claims, but as the Wayfarer parties suffered damages in California, where nearly all make their personal and professional homes, they may bring claims under the law of California, which has a strong interest in protecting its citizens. The New York-based New York Times insists it is entitled to New York law no matter where their harm was felt, but California law remedies harms suffered in California by California residents. Under either California or New York law, the Wayfarer parties have stated a claim for defamation against the New York Times, even under the actual malice standard. The New York Times contends that the article and video merely reported facts and thus the New York Times is shielded by the fair report privilege. Yet in the same breath, the New York Times also insists that its defamatory statements are not factual at all, but rather hyperbolic, non-actionable opinion. Neither theory holds up. The FAC also states claims for false light, promissory fraud, and breach of implied in fact contract. Even if the motion is granted, it should be granted only with leave to amend. So they get into all of it, and let's go to page 16. And I'm not going to share all of the case law and things like that. The FAC gives the New York Times adequate notice of the claims against it. The FAC alleges that the New York Times conspired with Lively, Reynolds, Sloan, and Vision PR to advance a false and defamatory narrative concerning the Wayfair parties, ultimately coordinating a near simultaneous drop of the article, video, and CRD complaint. The allegations in these three documents fall into two principal categories. One, allegations that certain of the Wayfair parties engaged in sexual misconduct towards Lively, and two, allegations that the Wayfair parties orchestrated a retaliatory smear campaign to damage Lively's image and reputation after she purportedly reported their alleged misconduct. Those allegations are false, and the New York Times either knew they were false or acted with reckless disregard as to their falsity. To the extent the New York Times is grouped in part of the FAC with other consolidated defendants, that is because, as alleged in the FAC, they conspired in secret over a matter of months. The precise contours of the New York Times' involvement were carefully concealed and impossible to ascertain fully without discovery. So boy, wouldn't that be great to get some discovery on all the colluding that went on? And again, this is one of the problems that does exist when it comes to news organizations, is you want them to be protected so they can't just have malicious people come after them if they don't like their reporting, but they got to be fair. They got to at least try to tell both sides of the story, or do they not? We'll find out. Now, a lot of people think there's no way this goes to trial. A lot of people think that this claim will just be dropped and New York Times won't even have to go to court. At the very least, if it goes to trial, you'll probably get a settlement from the New York Times, and at least maybe admitting that they could have done better. But it's probably better for them to double down on their beliefs that they did the right thing versus admit defeat. But think of that as you will. In the article and video, the New York Times offers its own commentary that goes well beyond merely reporting on the CRD complaint and therefore falls outside the scope of the privilege. For example, in both the article and video, the New York Times presented as unquestioned fact the false and defamatory claim that the Wayfair parties orchestrated a smear campaign, citing to thousands of pages of documents it had reviewed, and claims that the text messages show that the Wayfair parties had engaged in the wrongdoing of which Lively accused them. These extraneous comments and defamatory allegations, at least one of which the New York Times admits was not taken from the complaint, are not a report of the complaint and undoubtedly would produce a different effect on the reader. Again, so what they're arguing here is not everything that was in the New York Times made its way to the complaint. And I guess you would look at that and say, well, maybe Lively and her lawyers wanted to include more that wouldn't have to stand up to rigorous defense in the legal system. So they go into what they're allowed to do in the California system versus the New York. The article's false assertion of a smear campaign suggested the New York Times was making a factual statement. Black's Law Dictionary defines the phrase smear campaign as the deliberate telling and repetition of untrue or distorted stories about a person in order to make others lose respect for that person. The phrase is inherently factual in that it suggests that a person waging such a campaign is spreading stories that are untrue or distorted. The case cited by the New York Times are again entirely inappropriate and opposite. So then they get into some of the case law there. We're going to just continue our legal journey to page 28 where it all sums up. So this is the summary. The statements at issue here were made not in an editorial or letter, but rather in an explosive feature-length expose reported by, among others, the New York Times Pulitzer Prize-winning star journalist, Toohey, based on their own review of thousands of pages of text messages and emails. The New York Times statements in the article and video are not couched or qualified by equivocal language suggesting that the New York Times or Toohey were expressed an opinion. They were presented as statements of fact based on firsthand knowledge of the evidence. In that context, a reasonable viewer would have interpreted the New York Times smear machine and smear campaign statements not as mere hyperbole, but instead as provable, verified assertions of fact. Statements of this nature are not shielded from suit as non-actionable opinion. And this is the problem, right? As a idiot, non-legal expert. I look at this and I go, it seems like he's making a point to me, and we'll see what the judge has to say. The New York Times statements state or imply that the Wayfair parties engaged in grossly immoral conduct to cover up even more grossly immoral conduct, and such statements resulted in the destruction of their reputations and careers. The statements by the New York Times cannot be and were not construed as mere statements of opinion or of hyperbole. They were false statements of fact, and if the court finds that the statements could be reasonably construed as either fact or opinion, the issue should be resolved by a jury, thereby warranting the denial of the motion. Good government, and then they show that. The New York Times argues that the Wayfair parties have to satisfy the actual malice standard because of Baldoni's status as a public figure in New York's amended anti-SLAPP law. Though California and New York law diverge on whether the actual malice standard applies to all of the Wayfair parties, it is irrelevant for present purposes because the FAC adequately alleges actual malice with respect to each of them. To plead actual malice, a plaintiff must allege a statement was made with knowledge that it was false or with reckless disregard of whether it was false or not. So that while reckless disregard cannot be fully encompassed in one infallible definition, the defendant must have made the false publication with a high degree of awareness of probable falsity or entertained serious doubts as to the truth of his publication. Construed as true, the FAC's allegations set forth plausible grounds to infer actual malice. Actual malice is subjective, but a court typically will infer actual malice from objective facts. And then they cite some legal issues there. Here, it is not just the New York Times failed to adequately investigate, but rather that it did investigate and obtained and reviewed communications that disproved what it later published, and that it edited and spliced documents to mislead viewers, willfully disregarding, let alone manipulating information, casting doubt on a story, is altogether different from negligently failing to investigate in the first place. All right, I guess they're talking about that $250 million emoji and other left out, text messages where a publisher undertakes. So then they get into the citing the case law. We continue. The New York Times admits it did undertake an investigation. As alleged in the FAC, the New York Times made clear that the article and video were not merely resuscitation of Lively's complaint, but were instead a work of independent investigative reporting. As alleged in the FAC and conceded by the New York Times, the substance of the reporting was based on thousands of pages of text messages. So they mentioned that. The notion that Lively's bad press in August of 2024 was actually caused by an untraceable smear campaign is so inherently improbable that only a reckless person would have put the claim in circulation. There were obvious reasons to doubt the veracity of these statements in light of the reporter's common sense. The New York Times' prior reporting and the relevant primary source documents and communications that the New York Times obtained and that its reporters claimed to have reviewed. Not only were New York Times reporters privy to Lively's missteps in real time along with the world, they also reviewed private internal communications amongst the Wayfair parties directly refuting the article. Worse, the New York Times worked on the article for many weeks before publishing, perhaps since October 2024. Cue the metadata, yet the New York Times deliberately waited until the last possible moment to seek a response from the Wayfair parties. Indeed, on the evening of December 20th, Toohey contacted the Wayfair parties for a response by the next morning concerning explosive and false allegations. Yeah, something like 9, 10 p.m. West Coast time. The Wayfair parties denied the allegations and specifically warned Toohey that her story was false and based on cherry-picked and context-free communications spliced into a provably false narrative. A publisher need not accept denials, however vehement, before publication. But here, the New York Times could verify the denials because it had purportedly reviewed those communications. Purposeful avoidance of the truth supports a finding of actual malice, Hart Hanks. At this stage, the Wayfair parties have met their burden to plead facts given rise to the plausible inference that the New York Times published the allegedly defamatory article and video with actual malice. The test is whether the complaint is plausible, not whether it is less plausible than an alternative explanation. The jury may ultimately agree with the New York Times, but it is the jury that must decide. The false light and promissory fraud claims should not be dismissed. False light is so then they go into the other claims they don't want to dismiss. They talk about California law. Here on the evening, and this is the juiciest part if you ask me. Here on the evening of December 20th, 2024, the New York Times promised to delay until noon the next day so the Wayfair parties could respond to questions and inaccuracies. The Wayfair parties accepted the offer and tried to correct the record, albeit in the context of a brief overnight window of time during the holidays. Yeah, can you imagine you're with your family, you're baking Christmas cookies, and then all of a sudden, code red, 911, we got an issue. As alleged in the FAC, the New York Times outreach to the Wayfair parties was a ruse. The New York Times never intended the Wayfair parties to respond. The New York Times had already decided that the article and video would drop regardless of feedback from the Wayfair parties, as shown by the fact that both the article and video were ready to go at least days before the New York Times contacted the Wayfair parties. Indeed, although the Wayfair parties accepted the New York Times offer and scrambled to respond in just hours, the New York Times published early and without warning at 7:11 a.m. Pacific Standard Time. The release of the false article and video damaged the Wayfair parties. I mean, look, you show that to a jury. I don't care what the law is. You show a jury that they gave you 12 hours to respond, and then 7 hours before the deadline, they publish anyway. Wow. Now might not be illegal at all, but boy, is it bad faith. The Wayfair parties' promissory fraud and implied contract claims cannot be dismissed as duplicative. So then they talk about all these other issues. But I think that's really what it comes down to, is they're saying it just wasn't a fair fight. They didn't have a chance to respond. And more importantly, they're saying that the proof is in the pudding, that the New York Times saw the evidence and avoided it. You know, it's one thing to be like, whoops, I didn't know there was evidence to the contrary. They saw it, they avoided it. And that's the issue with where we live in today's society, right? Is that they always say, better to apologize and ask permission. Well, just not when you're defaming people. So here's what Lady C had to say. And again, this is, of course, Brian Friedman, power attorney et al. By the way, I'm going to be in LA this week. Should I try to get an interview with Brian Friedman? Do you think he would do an interview with me? Maybe. I've been following him for a long time. We'll see. Here's what Lady C had to say as she sums it up. She's been following this. As someone who has had the last 5 decades of her life blighted by deliberate false reporting from newspapers, I have every sympathy for Justin Baldoni and the Wayfair Studios victims of the smear campaign that the New York Times spearheaded on behalf of Blake Lively and Ryan Reynolds last December. It is therefore gratifying to note that Brian Friedman, power attorney, has opposed the New York Times' attempts to have itself struck out from the Wayfair lawsuit by simply making the point that publication was not neutrally reporting on fact, but was actually propagandizing on behalf of the Reynolds, allowing its pietistic reputation to become a sledgehammer with which to break down the innocent Justin Baldoni's reputation. Some time ago, I pointed out that I had been told by an eminent Hollywood insider who deplores the way the Reynolds and their cohorts have been behaving, that the couple and the New York Times had been colluding with one another for months before publication. Well, Friedman's brilliant riposte to the New York Times' attempts to have itself removed as a defendant from the case has now been filed and confirms that fact, as well as laying out the unethical way in which the New York Times cravenly behaved. I can't see how Judge Lehman can possibly allow that publication to hide behind press freedom when it knowingly, unconscionably, and unethically allowed itself to be used as the disseminator of false information calculated to destroy the careers of professionals whose only crime was to misjudge the malice, malafides, and rampantly unlawful ambition that lay behind the motives and actions of Blake Lively and Ryan Reynolds. So they've hired a former CIA operative to control the damage to their reputations, doubtless with the corollary of undermining the reputations and veracity of anyone who might stand in the way of their destructive objectives. These displays of misuse and abuse of power are as instructive as they are sickening. I only hope that Judge Lyman doesn't let the New York Times get away with the abuse of power and privilege it has indulged in and whose consequences it is attempting to escape from. I will conclude with the observation that I am a staunch advocate of freedom of the press, to such an extent that I refused the police's invitation to take action against the press during Operation Weeding, largely because Hacked Off in the UK was trying to introduce dangerous censorship by means of a privacy law that would have protected celebrities' privacies. I don't know anything about the UK laws. So they continue, it has patently defamed Justin Baldoni and its other Wayfair victims, and it should be made to pay the price. Any other course of action will result in a deprivation of the rights of the individual. And that's what's so interesting here, is that we're not even in the trial. So at least give it a fair trial, right? And this is the problem with the press, because I am also a staunch First Amendment person, freedom of the press, absolutely. But the press has to try to get it right. You know, when I was getting sued with these, when I was getting threatened with this $120 million defamation lawsuit last year, they were accusing me of only telling one side of the story, right? They were accusing me, oh, we're going to sue you if you're lying. And of course, they haven't sued me because I wasn't lying. And I was trying to get the full story. And it turns out I was on the right side of the story. It's just that the person that was attempting to sue me and silence me, really, didn't realize that I had found out that they had sent me fraudulent information. So in that case, I was on the right side, but I had to really try hard as a journalist to get the facts. And knowing as an independent journalist, I didn't have the New York Times behind me. You know, $1 billion machine behind me that has all the lawyers in the world and knows how far they can take things. I didn't have that. And I tried so hard to get it right, and I did get it right. Now, journalists aren't always going to get it right, but if you can prove that they're not even trying to get it right, that should at least get you to a trial, right? We'll have to see. I'll give you all these updates and more as they come. That's it for me right now. Have a good one, folks. We'll see you later.